I have presided over thousands of disputes during my years on the bench, and I thought I had heard every excuse, every accusation, and every dramatic courtroom declaration imaginable. But there is one case I still remember with remarkable clarity. A woman stood in my courtroom, pointed toward the bench, and announced that she did not trust the court, did not trust the process, and did not believe she could receive a fair hearing. The shocking part was not what she said. The shocking part was what happened when I reached for a single document she had signed herself months earlier. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. My name is Judge Judith Harper, and over the years I learned that people reveal who they are long before they realize they are doing it. This case involved a woman named Karen Mitchell, 46 years old, confident, articulate, exceptionally persuasive. The kind of person who could walk into a room and immediately command attention. The dispute itself appeared straightforward. Karen had filed a civil complaint against a home renovation contractor named Michael Bennett. According to her lawsuit, Michael had abandoned a remodeling project halfway through construction, overcharged her, and left her property in worse condition than before. At first glance, her allegations seemed serious. Michael sat quietly at the defense table. He was not polished. He was not charismatic. His suit looked slightly too large, and his nervousness was obvious. But something about his demeanor struck me immediately. He looked worried, not manipulative, not defensive, worried. There is a difference. Years on the bench teach you that people under genuine stress behave differently from people performing stress. Gann, meanwhile, appeared completely comfortable, almost too comfortable. As the proceedings began, she addressed every question with confidence. She maintained eye contact with jurors. She spoke clearly. She appeared prepared for every possible challenge, and yet something felt off. I could not explain it at first. Judges develop instincts over time, but instincts alone are never enough. They simply tell you where to look more carefully. Then Karen began discussing prior court proceedings connected to the dispute. That was when the atmosphere changed. She claimed earlier mediations had been biased. She claimed administrative hearings had been unfair. She claimed officials had ignored her concerns. Then she said the sentence that immediately captured the attention of everyone in the courtroom. I don't trust this court. The room went silent, not because criticism is unusual, because certainty is she didn't say she was concerned. She didn't say she was worried. She declared that she did not trust the very process she had voluntarily chosen to enter. I watched the jurors. Several exchanged glances. Michael looked confused. Even the court reporter briefly looked up. Years of experience have taught me that when someone attacks the legitimacy of a process, an important question follows. If you never trusted the process, why did you choose it? That question stayed with me. As Karen continued speaking, I reviewed the case file in front of me, page after page, motions, applications, disclosures, agreements. Then my eyes landed on a document buried deep within the record, a routine document, the kind most people sign without a second thought. At that moment, I felt something I rarely feel during trial, curiosity, because the signature at the bottom belonged to Karen herself. And the words above that signature would soon create one of the most unforgettable moments I have ever witnessed from the bench. What nobody in that courtroom realized, not Karen, not the jurors, not even Michael, was that she had already put her trust in this court, in writing, with her own signature. And when I finally read that document aloud, the entire room froze. The morning after Karen Mitchell declared she did not trust the court, I spent extra time reviewing the file, not because her accusation offended me. Judges who take criticism personally rarely last long on the bench. What interested me was the contradiction. People often reveal the truth through inconsistencies. When actions and words point in opposite directions, I have learned to pay attention. Corin's words claimed distrust. Her paperwork suggested something else entirely. As proceedings resumed, the courtroom filled with a different kind of energy. The previous day's confrontation had spread through the courthouse. Lawyers passing through the hallway whispered about it. Court staff had heard about it. Even some spectators appeared unusually eager to watch. Karen seemed to enjoy the attention. That observation mattered. In my experience, people seeking justice usually focus on outcomes. People seeking validation focus on audiences. The distinction is subtle, but important. Michael Bennett returned to the defense table looking exhausted. Overnight, his attorney had organized financial records, contracts, invoices, photographs, and inspection reports. The evidence occupied nearly an entire section of counsel's table. Karen arrived carrying only a small folder. Yet she appeared far more confident than the side carrying thousands of pages of documentation. That caught my attention. Confidence is not evidence. Sometimes it is merely confidence. The hearing resumed with testimony regarding the renovation project. Karen described missed deadlines, incomplete work, unexpected costs, water damage, electrical issues. The jurors listened carefully. Some even took detailed notes. At first, her testimony seemed compelling. She spoke with precision. Dates, rounds, conversations, promises she claimed had been broken. Had I stopped listening there, I might have viewed her case very differently. But years on the bench teach patience. The first version of a story is rarely the complete version. Michael eventually took the stand. He appeared nervous from the moment he sat down. His voice lacked Karen's polish. He occasionally searched for words. He made small mistakes while recalling timelines. Ironically, that made him seem more believable. Truth is often messy. Rehearsed narratives rarely are. Then Michael introduced something unexpected. A series of signed change orders. For viewers unfamiliar with construction disputes, change orders are documents authorizing modifications to a project. They record additional requests, altered materials, expanded work, and revised costs. The stack was substantial. Karen's expression changed. Only slightly, but I noticed judges survive professionally by noticing slight changes. One document became 2, 2 became 10, 10 became 20. Every additional request appeared to carry the same signature. Karen Mitchell, the jurors noticed as well. I could see them comparing testimony to paperwork. That process is where cases are often won or lost. Facts are stubborn things. Then Michael's attorney approached a topic that seemed unrelated. Alternative dispute resolution, mediation, arbitration settlement conferences. The jury appeared confused. Karen appeared irritated. That reaction interested me immediately. The attorney produced another document, not the one I had found. A different one. He established that Karen had voluntarily participated in multiple stages of the legal process before filing this lawsuit. Voluntarily. That word mattered. The attorney then asked a simple question. Ms. Mitchell, if you believed every stage of this process was unfair, why did you continue requesting additional hearings? Karen hesitated for the first time, only briefly, but long enough. People rarely struggle with answers they have prepared. She eventually replied that she was trying to exhaust her options. The answer sounded reasonable, yet something about it felt incomplete. Because buried inside the court file was a document that would soon make that explanation far more difficult to maintain. I glanced again at the page I had reviewed the previous evening. The signature was unmistakable. The language was unmistakable. And the more testimony I heard, the more important that document became. What Karen did not realize was that the very paper she signed months earlier contained a statement so clear, so direct, and so devastating to her courtroom argument that when the time came to read it aloud, even her own supporters would struggle to defend what she had been claiming. And that moment was getting closer. By the third phase of the trial, the case had become less about a renovation dispute and more about credibility. And credibility in a courtroom is everything. You can have strong emotions. You can have compelling arguments. You can even have public sympathy. But if your credibility begins to crack, everything built upon it becomes vulnerable. That morning, I watched the jurors carefully as they entered the courtroom. Their body language had changed. Earlier in the proceedings, many appeared sympathetic toward Karen Mitchell. Her confidence had made her story sound convincing. Now, however, they were paying closer attention, not to her accusations, to her inconsistencies. That shift can be difficult for a litigant to detect, but judges notice it. The defense continued presenting evidence, project schedules, get-amongst exchanges, inspection reports, comment records. Each document by itself seemed ordinary. Together, they painted a very different picture than the one Karen had described. The renovation project had not simply expanded. It had expanded repeatedly. Additional rooms, upgraded materials, custom requests, last-minute changes. And nearly every change carried Karen's written approval. As the evidence accumulated, I noticed something else. Karen was becoming increasingly frustrated. Not emotional, not upset, frustrated. There is a difference. Emotional people react to circumstances. Frustrated people often react to losing control of a narrative. She interrupted more frequently, objected more aggressively. Repeated claims about unfair treatment. Repeated accusations of bias. Repeated statements about her distrust of the court. The repetition itself became revealing. When facts are strong, people rely on facts. When facts become weaker, some people rely on volume. Then came a moment I will never forget. Michael Bennett's attorney displayed a timeline of events. The dates stretched across several months, every major decision, every signed authorization, every dispute, every hearing, every filing. The timeline revealed a pattern. Karen had repeatedly chosen to continue participating in the process. Again and again and again, the jury noticed. I could see several members reviewing their notes. That is always significant. Jurors rarely revisit notes unless they sense a contradiction worth examining. Then the attorney asked Karen a simple question. Ms. Mitchell, at any point were you forced to enter mediation? No. At any point were you forced to request review hearings? No. At any point were you forced to sign participation agreements? No. The courtroom grew quieter with each answer. Years on the bench teach you that some of the most damaging testimony comes from a witness's own mouth. No confrontation, no accusation. Just answers. Karen appeared to recognize where the questioning was heading. Her posture changed. She leaned forward, crossed her arms, began answering more defensively. The psychological shift was obvious. People become defensive when they sense danger. And danger was approaching. Because while the defense had established that Karen voluntarily participated in the process, they still had not introduced the most important document, the one sitting in my file, the one I had reviewed multiple times. The one bearing her unmistakable signature, a routine waiver form, at least that is what most people would call it. But years of legal experience have taught me that ordinary documents often contain extraordinary consequences. Especially when people fail to read what they sign. The defense attorney glanced toward me. I knew exactly what he was preparing to introduce. Karen seemed to know as well. For the first time since the trial began, she looked genuinely nervous. Not annoyed, not irritated, nervous. That distinction mattered, because she had spent days attacking the legitimacy of the court, days questioning fairness, days portraying herself as someone dragged unwillingly into a broken system. Yet hidden within that waiver was language that would directly contradict everything she had been telling the jury. And once those words entered the record, the entire case would take a dramatic turn that nobody in the gallery saw coming. The fourth day of proceedings began with a tension I could feel before a single word was spoken. Courtrooms have their own atmosphere. After enough years on the bench, you learn to sense when a case is approaching a turning point. This was one of those days. Karen Mitchell entered the courtroom with noticeably less confidence than she had shown during the first week of trial. The change was subtle. Most people would not have noticed. I did. The shoulders were slightly tighter. The smile appeared less natural. The eye contact came less frequently. Pressure was beginning to work against her. Pressure is a remarkable thing. It strips away performance. It reveals reality. As the jury settled into their seats, Michael Bennett's attorney rose and approached the evidence table. He carried a single folder, not a thick binder, not a stack of exhibits. One folder. I immediately knew what it contained, the waiver. The document that had quietly sat in the case file while accusations of unfairness echoed throughout the courtroom. The attorney requested permission to introduce Defense Exhibit 32. I granted it. Karen shifted in her chair. That movement alone told me she recognized the exhibit. The document appeared on the courtroom screen. At first glance, it looked completely ordinary. Standard legal formatting, several paragraphs, a signature block, nothing dramatic, nothing emotional, nothing that would capture the attention of an audience unfamiliar with legal proceedings. But legal cases are rarely decided by dramatic moments alone. They are decided by details. The attorney began asking foundational questions. When was the document signed? Who presented it? Was Karen given time to review it? Was she under any pressure? The answers were straightforward. The document had been signed voluntarily. Karen had received it weeks before the mediation process began. She had been advised to review it carefully. She had signed it herself. No one disputed those facts. Then came the critical question. Ms. Mitchell, is this your signature? The courtroom became very quiet. Karen stared at the screen. For several seconds, she said nothing. Then she answered, Yes, one word, but an important one. The attorney nodded. He looked toward the jury, then back toward Karen. Years of courtroom experience have taught me that effective attorneys rarely rush important moments. They allow facts to breathe. They allow jurors to absorb significance. Then he asked another question. Before signing this document, did you read it? Karen hesitated. Again, another hesitation, another crack. Eventually, she replied. I skimmed it. A few jurors exchanged glances. I noticed Karen noticed too. That answer had not helped her, not at all. The attorney approached the screen. Using a digital highlight tool, he enlarged a specific section. The text became visible to everyone. The gallery leaned forward. Even spectators who had previously seemed distracted were now paying attention, because something was happening, something important. The highlighted paragraph sat only inches above Karen's signature. And as I read the language silently to myself once more, I understood exactly why the defense had waited until now. Timing matters. Evidence often becomes most powerful when introduced at the precise moment a contradiction becomes impossible to ignore. The attorney turned toward me. Your Honor, with the court's permission, I would like the relevant provision read into the record. I looked toward Karen. For the first time since this trial began, she appeared genuinely alarmed. Not frustrated, not irritated, alarmed, because she knew what those words said. Or perhaps she had just remembered. Either way, the result would be the same. The very document she had voluntarily signed contained language acknowledging the fairness, neutrality, and legitimacy of the dispute resolution process she now claimed she never trusted. And in just a few moments, those words would be read aloud before the jury. What happened immediately afterward would become the defining moment of the entire trial. There are moments in a courtroom when an entire case pivots on a single piece of paper. Not a dramatic witness, not a surprise confession, not a hidden video, just words. Words someone willingly signed. This was one of those moments. The courtroom was so quiet that morning that I could hear pages turning at the counsel tables. The jury watched attentively. Karen Mitchell sat rigidly in her chair. Michael Bennett looked almost afraid to move. Everyone understood that something significant was about to happen. The defense attorney stood beside the evidence screen and adjusted the display one final time. Then he began reading, slowly, clearly. Every word echoed through the courtroom. The undersigned acknowledges that the mediation and dispute resolution process is voluntary and fair. The attorney paused. No one moved. Then he continued. And further acknowledges confidence in the neutrality of the participating officials and agrees not to challenge the legitimacy of the process after voluntarily accepting its terms. The silence that followed was unforgettable, Donfiddle silence. The kind that arrives when a room full of people simultaneously understands the significance of what they have just heard. I looked toward the jury. Several members immediately turned their attention toward Karen, not toward the document. Toward Karen, because the contradiction was now impossible to ignore. For days, she had repeatedly declared that she never trusted the process, never trusted the court, never believed the system was fair. Yet months earlier, she had signed a document explicitly stating the exact opposite. And she had admitted the signature was hers. She had admitted she signed voluntarily. She had admitted she was not pressured. She had admitted she had the opportunity to read it. The defense attorney did not need to argue. The document was speaking for itself. Years on the bench have taught me that evidence becomes powerful when it requires no explanation. This was that kind of evidence. Then came the moment I will never forget. Karen suddenly stood, without permission, without warning. "This is ridiculous," she shouted. The gallery gasped. The jurors stared. Court security immediately became alert. He instructed her to sit down. For several seconds, she remained standing. Her face was red. Her composure had vanished. The calm, confident woman who had dominated the courtroom during the first days of trial was gone. In her place stood someone desperately trying to regain control of a narrative that was slipping away. Then she made a mistake, a very serious mistake. She pointed toward the screen. "I only signed that because I assumed everyone was acting honestly." The words left her mouth before she seemed to realize what she had said. The courtroom froze, because that statement destroyed her central argument. If she signed the waiver believing the process was honest, then her repeated claim that she never trusted the process was simply untrue. I watched the realization spread across the jury, one by one. Like dominoes falling, Karen realized it too. Her expression changed immediately. The damage had already been done. No attorney could retract it. No explanation could erase it. The statement was now part of the record. And then something remarkable happened. Michael Bennett, who had spent most of the trial quietly defending himself, lowered his head and closed his eyes. Not in celebration, in relief, the kind of relief that comes when someone finally sees the truth, breaking through months of accusations. I looked across the courtroom and understood that we had reached the turning point. The case was no longer about renovation disputes. It was about credibility. And credibility had just suffered a devastating collapse. But the most important moment was still ahead, because before this trial ended, Karen would be forced to answer one final question from the bench, a question she had spent the entire case trying to avoid. And her answer would determine how the jury ultimately viewed everything she had said from the very beginning. The final day of the trial arrived with an atmosphere unlike any other stage of the proceedings. The tension was gone. The uncertainty was gone. What remained was clarity. Not complete agreement on every detail of the renovation project. Not complete agreement on every conversation that had taken place, but clarity about something far more important. Credibility. As I entered the courtroom that morning, I noticed how differently the room felt compared to the first day. Back then, Karen Mitchell had controlled the narrative. She had projected confidence, authority, certainty. Now, the jury was looking beyond confidence and focusing on evidence. That is exactly how the justice system is supposed to work. The attorneys delivered their closing arguments. Michael Bennett's attorney kept his presentation remarkably simple. He did not rely on emotional appeals. He did not attack Karen personally. Instead, he walked the jury through the documents, the contracts, the change orders, the payment records, the emails, and finally the signed waiver. Again and again, the evidence pointed toward one conclusion. Karen had voluntarily participated in the process she later claimed she never trusted. Then Karen delivered her own closing statement. She spoke passionately, at times emotionally. She argued that paperwork should not outweigh her personal experience. She argued that she felt betrayed. She argued that the process had disappointed her. Some of those feelings may very well have been genuine. But courts cannot decide cases based solely on feelings. Courts must decide cases based on facts. That distinction matters. Sometimes it is the most important distinction of all. After deliberations, the jury returned. I still remember the four persons standing with the verdict form in hand. The room became completely silent. No whispers, no movement, no distractions. Only anticipation. The verdict was read. The jury found in favor of Michael Bennett. Karen's claims were rejected, not because she lacked confidence, not because she lacked determination, but because the evidence did not support the story she presented. As the verdict was announced, Michael lowered his head. I could see emotion in his face. Months of allegations, months of legal expenses, months of uncertainty. Finally ending, Karen remained seated, answerless, staring straight ahead. I have often reflected on that moment. Not because of the verdict itself. Cases are won and lost every day. What stayed with me was the lesson behind it. After the jury was dismissed, I addressed the courtroom one final time. I spoke carefully. Because some lessons deserve to be remembered. I explained that disagreement with an outcome does not automatically mean a process is unfair. Disappointment is not proof of corruption. Frustration is not evidence of bias. And losing a case does not invalidate the system that heard it. Those principles are essential to justice. Without them, every unfavorable result could simply be dismissed as illegitimate. The courtroom gradually emptied. Jurors departed. Attorneys packed their files. Court staff completed their final tasks. Eventually, only a few people remained. As I gathered my papers, my eyes briefly returned to the signed waiver resting on the bench. A simple document, one signature. A few paragraphs, nothing extraordinary, and yet it had exposed the central contradiction of the entire case. Years on the bench have taught me that truth often hides in ordinary places, not in dramatic speeches, not in emotional accusations. Not in headlines, in documents, facts, choices, records. The things people create when they believe no one will ever examine them closely. Karen entered that courtroom, insisting she never trusted the process. But her own signature told a different story. And in the end, it was not a witness, an attorney, or even a judge who exposed the contradiction. It was her own words. That is why this case has remained with me for so many years. Because it serves as a reminder that truth has a remarkable quality. You can argue with it. You can deny it. You can try to outrun it. But eventually, if the facts are allowed to speak, truth catches up. And when it does, no accusation is louder than the evidence itself.